So I've made a few videos about this Parliamentary Papers Act and the privileges. It always seems like when I'm listening back to the videos, I miss something out, or I could have made it a bit more clearer or easy to understand. So I'm going to try and condense it all down to a simpler video now. This is the Parliamentary Papers Act, 1840. It's a very short act. Most people in Parliament, even MPs who don't study that much, think that it's only for things that when Parliament makes an order itself, like there and then, like the Speaker makes an order, like publish some books, right? And then the publisher goes and publishes them, or even publishing the standing orders, or which are the rules that you follow, which is ironic. That's the ironic part in it when you understand it. Publishing the standing orders, order the standing orders to be published, right? Or there was a manual and procedure in the public business, right? But it can't be just for that. It's not only for that. And this act was made after Parliament burned down and a lot of the records were lost, 1840. Now, here's the context, right? These are the standing orders, 1685 to 1822. At this point, there wasn't any rules for public petitions in the public business, right? So 1822 is when before this act was made, right? Now, in these standing orders, there's no, it's private bills and other matters. So but these are our orders. And these are what the public these are not just given to the members of the House, these are given to the public to follow as well, right? Now, in this book, private bills generally, now in this book, there is public matters. But the public matters are like for acts of law, bills, religion, trade, money, or temporary laws, not for public petitions of grievance. Public petitions of grievance were a long-established tradition and based on custom and tradition. From the observation of due process 1368, the commonalty put forth their petitions to the king according to the law of the land, right? And then they're not allowed to, you can't arrest people without a matter of record or original writ. Okay, which I think means that you need summons and warrants and things like that, or at least you have to set it in writing with an official petition, right? I'm starting to wonder if they stopped it so people doing civil mesne process for petitions couldn't arrest people without first applying to Parliament for warrants and things like that, or else that's why you prevent lynching mobs and things like that. But bills on religion that affect the country, it's public matters but not private business. Bills on trade. So that's when you get all these petitions to do with local guilds and paper makers and all kinds of things like money and temporary laws, right? So these are in public matters. Then you've got private bills, which it tells you what they're all for. Turnpike roads, even turnpike roads were under private bills. Maybe because that's for local councils, were considered private for local area. I don't know. But it tells you what they are here. Divorce was private matters. Navigable canals were under private matters. Most of these eventually got put into acts of law and dealt with through acts of law, which the parliamentary agent has told me. That's why there's hardly any private bills, particularly for roads, canals, railways. I think they're dealt with under an act of law, similarly to how now the Scheduled Monuments Act deals with everything under that act. But you still can petition the Secretary of State or Minister, because in that act you can ask them for something. You would ask them through a petition, surely, right? In Scotland and Wales to protect a monument, for example. Tunnels and archways. So all this was all under private bills anyway, right? If you've got any on private land, but also bridges, town halls, marketplaces, churches, chapels. So I think when it comes to cemeteries and things like that, but these are in Parliament, not in the local council. But I think religion might actually be cemeteries might fall under religion, under public matters. But then you've got trade, so that's like all your different companies and businesses, private, public business. Now, So they did actually have public matters. I've got another. I've forgotten where it is now. I've got one of these which is a little bit earlier than this, and I've just forgotten where it is. I think it might even be the PDF. It might even be the PDF version. It's a little bit earlier than the 1822 one. I'm just trying. Oh, I know where it is now. Hold on. Right. So these are many of the standing orders, 1685 to 1822, but it doesn't tell you exactly which are which and at what point they changed between that time. But they're accounted for that time. Now, here we've got a very nice antique sort of looking book here, which is 1801. These are the standing orders relative to private bills, etc. For 1801, right? And in here, so 1801 is before 1822. So this book, Standing Orders from 1801, is before 1822, but not going as back as far as 1685. So I think these are amended for 1822. So what's it like in between that time? Well, in between that time, it's like in here. There aren't actually, this is a Hansard one, and there are no distinctions between private and public business, really. Sorry, they've got private bills generally, and then they've just got different turnpikes, navigable canals, bridges, small debts, pavings, letters patent, divorce, trade, religion, and public money. They're all under one they're just under their own subject. They're not, this is public, this is private, right? And in this, at the back, now this is when we get into the business of parliamentary privilege, right? You've got the fees. When we get to the fees, oh no, actually, there aren't any fees in here. Sorry, there aren't any fees in here. There aren't the fees. Right? They're not in there. There are no rules for public petitions, but what we call a public business from private business, like I said, there's no differentiation between it, according to this. Let me just double check to see if I'm not wrong. Islands at the back, right, so there aren't any fees in this, and there are no rules for public petitions, and this is 1801. Now, in 1822, right, we do have a differentiation, right? Public matters are defined as religion, trade, money, and temporary laws, but there aren't any rules for public petitions. So if these are public matters, what are public petitions? Well, what these actually are everything to do with trade, religion, money, and temporary laws for bills, but public bills, right? Now, matters of personal grievance or judicial matters were like a grievance of privilege, which is our right to do anyway. But they're not private bills or public business. Now, ironically, this is something that I need to say. This needs to be spoken. Currently, the new e-petitions website doesn't really want you to do personal grievances or judicial matters or things that need immediate attention. So what's left? Well, what's left is only really our suggestions for public bills or alterations in public business that government haven't already got under its manifesto or private members' bills. So that would just be general matters that aren't private grievance, which would be these public matters, right? But the whole point, right, of having the rules for public petitions, which were eventually put into public matters, right? I think, if I can find it quick enough, is for public petitions, you know, of grievances and It says allegations. I don't know if to pause it again now. Right, so the presentation of public petitions, in the paragraph for the presentation of public petitions, it's got the word allegations, right? Presentation of public petitions has got allegations, and it might be to do with privilege or a judicial matter or an urgent personal grievance. But what I've realised is they're not actually under public business, because public business is not private business or private bills, but public business is all your like trade, religion bills and so forth. Now, what the e-petition service is actually doing at the moment with their policy is not letting us do any allegations, any privileges, urgent grievances or anything like that, what the presentation of public petitions is the rules for, the whole point in it. Because it's actually just not normal public business, which is in a separate section here for like, trade. So, public business is like the business that was defined as in the public, but not private, from the first lists before, public matters here, right? Public matters are here, and then private matters, but these aren't petitions of grievance. These aren't the petitions of grievances or judicial matters or things that need urgent action or attention. They're public matters in the sense of like law that the government was working on, but you propose yourself in public as opposed to private. But there was no differentiation here in 1801 between public or private at all, right? In fact, they had private bills generally, but they were all trade, religion and divorce and things like that were just different subjects, right? They were just different subjects. So when you've got the Bill of Rights that says Parliaments are called to redress all grievances and amending and strengthening the laws, when you say public petitions, it actually means once they introduce the rules and laws for public petitions, but they're not necessarily public matters like these, right? But they call e-petitions public petitions, and they said it's for the same purpose as paper ones, but they're only letting you do these on there, or the extended modern version of these. Really, they're only letting you do public matters, which isn't even what we get when we actually, because public business here is separate to, but it's also clearly including, but petitions for private business are separate from public business. But the presentation of public petitions, which only happened in 1842, for the proper rules for them, and George Strickland voted against those rules, and if you want to read all about it, read the 1832 committee report. It tells you all about the whole thing up to date to 1832, right? Now, this presentation of public petitions is only inserted in here, and it clearly is a different clause separate from public matters generally. Although there's nothing to say you can't have one of these public matters bills by petition, but they're separate from private bills business, right? After this, right? So this Parliamentary Papers Act, chronologically, is before there were any rules or acknowledgement for public petitions of grievance and privilege and all the rest of it, right? And it's only following this Act, right? It is when we even get rules for public petitions, which, George Strickland voted against, but there was a majority of the House in favour of those rules, right? But they only govern actually in the House. Now, I talked in another video, this is later now, this is 1856, but not that much later. This is another Hansard one, yeah? And we've got private bills and public business. And we've got these you see, so when it comes to privilege, and claiming for privileges. We've got the fees. You go to the fees section. It should just be before the appendix. So it didn't take ages spending time to get to it. Or is this index to standing orders? That was the House of the Lords section at the back. That's why I couldn't find it. Right, okay, general fees. Right, these are the general fees. If someone breaches your privilege, right, if your privilege has been broken, the privilege of the House of Commons, right, here are the fees. So you can have people brought in on contempt, summon, breach of privilege, etc. Now, those fees are not in there in 1801. They don't have them. But they do have them in here for 1822, including even a distinction of having knights, knights called in on contempt, right? Knights of the Empire. So here, for taking a knight into custody is more expensive than taking a gentleman into custody. So this is for breach of privilege. Now, what's important for the courts and Crown prosecution to know this, right? This is for breach of privilege that exists 1822. But there's no standing orders saying that you do it by petition, right? How do you claim breach of privilege? You do it by petition. Now, that's not introduced until 1842, right? Into the manuals, into the standing orders. It's in the back. And then how do you claim it? It tells you through a public petition, right? Over breach of privilege, right? But we've already, in 1840, right? We've already been given this very simple way to deal with it in the courts. Very simple way remedying the courts in 1840, before they put the rules for public petitions into these manuals, which says you can claim a grievance by petition, right? With the fees in the back. But the fees in the back were before 1840, right? But they didn't have the fees in there in 1822. But they did have the fees in there after, 1801. They didn't have the fees in there in 1801. Let me correct myself. They didn't have the fees in there in 1801. They have got the fees in there in 1822, but there's no Parliamentary Papers Act and no rules for petitioning. In 1840, they get this remedy for the courts. And then shortly 2 years after, they actually do get rules for public petitions and claiming grievance of privilege and the proper rules. But you wouldn't really need to claim it in Parliament because they've made this to sort out most problems. Now, what even are those problems? Well, we know what they are, what type of thing it involves or concerns. In Erskine May's parliamentary practice, the law privileges proceedings and usage of Parliament for misconduct against petitioners and others soliciting in order to either house. These are the things that these are examples. These aren't the definitive only things. There are a few just examples of things that you might be doing, right? But you can't be arrested or prosecuted because of the Bill of Rights. Obviously, because of the 1688 Bill of Rights. You've got the Tumultuous Petitioning Act, governing the soliciting of signatures to either houses of Parliament. Those are the preliminary proceedings. And I've got that voucher manual, the voucher manual, which I need to show you that as well. Now this is the voucher. I don't know how to pronounce it. It's a VACHER, right? These are the Vetcher's ones, and these were meant to be more official than Hansard even, right? Well, this is for the railway standing orders, but for the private business, in private bills. But like I said in another video, it's got preliminary proceedings. preliminary proceedings, not just proceedings actually in the actual house itself, right? Proceedings in the house, petition for bill, and preliminary proceedings. It's acknowledging that preliminary proceedings exist through standing orders for the usage, the law proceedings, privileges and usage of Parliament. For public business, it's acknowledged that by George Strickland, there weren't actually any rules. Back when they had these in 1822 and 1801, there were no rules for public petitions of grievance, right? There weren't any rules. It was a complete tradition. Observation of Due Process of Law, 1368, and the Tumultuous Petitioning Act and 1688 Bill of Rights. The Tumultuous Petitioning Act legislates and governs the soliciting of signatures to either Houses of Parliament or the King in public is a process of law acknowledged. If you're under 20 people, you don't need any permission or consent for it, but it is a legal process to either Houses of Parliament legislating from Observation of Due Process of Law 1368, Tumultuous Petitioning Act 1661 and 1688 Bill of Rights. And it clearly, this is a really important report from 1837. I can't remember if this is Hansard or the Journal, but whether it's Hansard or the Journal, it's the 8th of June. So that can help you find it, and it's under publication of papers, and it's page 1269 and 1270. It's either Hansard or the Journal, I've forgotten, but we know the exact date of it and the title and the page, so it can't be that hard to find it. And here, why was he debarred from redress? Because in his case, as in others, the privilege of Parliament protected the presentation of the petition, the printing for that petition, all of the documents connected with it, and of the accusatory evidence given at the bar, right? So that's your articles, even your evidence, like normal privilege in a legal case, even like you can have preliminary proceedings, you can have like in civil or criminal law, you can have like an order for to get evidence beforehand. So it's called pre-action disclosure, right? Pre-action disclosure. So pre-action disclosure is getting evidence before you even bring a case. It exists in law, so why can't it exist in parliamentary law, right? All your evidence is protected. That's like my YouTube channel and everything like that that's meant to be protected. And 38 degrees petitions, your signatures that you're collecting, right, is preliminary evidence. And the printing of the petitions is not just when Parliament order it to be published, because you need to get it put in the newspaper or now online if you want to promote it successfully, which is what they're doing on e-petitions now. And even Jacob Rees-Mogg said that's privileged. So this is a really important bit here. I've got the stuff that the BBC have got evidence that I need from Jeremy Vine and all kinds of stuff, things that are in local archives, libraries, National Archives. Even when people are doing the printing, when you ask a printer to print something for you and they refuse to print it, and if they won't take the VAT off it when we're entitled to have the VAT taken off it, and they won't even offer you a service, they're refusing to be your servant and to take on the work, right? That, you need to understand, is misconduct against petitioners by obstructing them and hindering them. If someone's offering a business like printing, they don't actually have the right to refuse business, and that might seem strange, like, how can you force someone to work for you? But it's almost like a police officer saying, I need a pen, and if he hasn't got one, he'll probably take it and say that he's using it in the interest of justice, right? You have got a legal right to have access to services. If a printer refuses to print something for you, like that Harry Screen print in Wimborne refused to print my stuff because I was arguing about the VAT when I'm clearly exempt as a small political body, right, which does not require to be VAT registered, it's contempt. You could be having them called into Parliament for contempt. Did you refuse to print these documents? which were needed to print 100 copies of the petition or the adverts. You can have them summoned into Parliament on contempt. None of this is getting used. There's meant to be all kinds of things that you can do and use for the proceedings of Parliament, but no one knows about it because Extinction Rebellion and Just Stop Oil are, obsessed with their EU law. They don't really need it because, they only need it when the warehouse gets raided and the police take all their stuff, right? That's contempt. But it's very rare that someone will turn down Extinction Rebellion or Big Brother Watch or someone like that. But there are these things which exist, or even if Big Brother Watch or Extinction Rebellion get their YouTube channel taken down, things like that, they don't do very often. But if that happens, these are meant to be the procedures to deal with it judicially, right? They're not getting used. No one's even doing private bills to Parliament in the private business, right? This proves what they're doing to you and what's being done to you, right? Which is unlawful, which is basically a violation of the 1668 Bill of Rights, right to petition. All your things are protected and privileged, and you've got a legal right to get and access services. I'm quite sure that if someone put a witness appeal out for a criminal case and the newspaper wouldn't publish it or someone wouldn't put it on a church door, there's laws in here for putting things on church doors as an official notice. If someone takes that notice of the church door, that's a breach of privilege, right? 38 Degrees are obstructing our petitions. 38 Degrees think that just because you get dodgy signatures, right, even if it's not your fault, they can seize and take your petition. That's not true, right? They can't. And actually, it is here in the Ethel Margaret Self case and the other cases in 1939, right? They're saying here that the petitions were accepted and put in the dirt here in the report, even when some of the signatures were invalid. They don't see the petition still gets proceeded with, right? And 38 Degrees need to accept that and stop acting authoritarian and taking our things and saying, oh, this is very serious, we'll get into trouble with Parliament. Yeah, you'll get into trouble with Parliament for they don't have any judicial authority at all. They want to have a petition site, they're publishing them, they're the equal standing of a newspaper, right? And when it's our petition and you're the creator, they don't actually have legal rights as a petition creator over it, not even for data protection, I don't think. 38 Degrees really need to get themselves sorted out because this 1939 committee report completely proves 38 Degrees wrong and Robin Priestley. I want Robin Priestley actioned against. He's been delaying me and he seized and took my evidence unlawfully, right? So this is what it all is. Now, this is meant to get rid of all these judicial problems with Parliament and summons and being in front of Parliament on contempt. Judges, sheriffs, bailiffs even, plaintiffs in the public or private business. There are records of it in the journal, people being called in, right? This puts an end to that because you can get all sorted out in the court simply, right? Because you're using standing orders. By order, processes and procedures that have been ordered to be followed by Parliament. They've been ordered for people who've been ordered to follow them. If you've got a company in business like McDonald's, right, the chief executive sets the company up by order of the executive that everyone will drive through the drive-through one direction and buy a burger, right? That's by the order of the executive, right? For Parliament, these processes and procedures are all by order of the House for people to follow them, right? And make use of the law, privileges, proceedings and usage of Parliament. Now, I think this, therefore, is exactly what John Tinker was talking about. People normally get a resolution in the courts from before the petition rules were even got into the... Here! You could get a resolution in Parliament, but after 1840, before the petition rules are put in, you could get a resolution in the courts with this, and then you wouldn't really be using the Bar of Parliament very often at all if you could get a resolution in the courts. Otherwise, you can get a petition for the Speaker and a certificate, right? And I don't think there were any records of it because they were all petty sessions. This is only for summary. So it's only petty sessions and then not a court of record. So there won't be any records for it. And then when we get on to the rest of this, you know, on the meaning of the words in it and everything else like that, it's for use in proceedings, right? In the publication. And you've got to publish things to promote public and private bills, public and private business. It's not just everything that's going out of Parliament, it's things that are coming into Parliament as well. And I think it's a very reductive interpretation to try and make out that this is only for the ordering the standing orders to be printed and ordering the manuals of procedure and Erskine-May books and manuals of procedure in public business to be ordered and printed, as well as the votes of proceedings, as well as the committee reports, all those things. We need to use standing orders and use the law to get under the authority. We're doing it under the authority of the House because it's like the 1661 Tumultuous Petitioning Act is the soliciting of signatures in public to either Houses of Parliament or the King, right? And that's the 1661 Act is by order of Parliament because they voted it through, and the King gave it assent by order of Parliament that you got to follow it, right? And that's what courts need to get their head around, why it's by order of Parliament and under the authority of the House. When they make an act of law, and the King gives it royal assent, the Speaker ordered it to be made law on votes of the House. He ordered it to be an act which is to be followed, like the Tumultuous Petitioning Act, the soliciting of signatures in public to either Houses of Parliament or the King. That's by order. That is, acts of law are by order of Parliament and the House, even what courts have to follow. So that's pretty much my idiot's guide to it. To add on to the other video, things that I might have forgotten to say or mention. And currently the e-petitions, they're trying to stop us from doing public. It definitely doesn't do private business, but the type of public business they're only allowing us to do now is kind of like what falls under. It doesn't even fall under the standing orders for public petitions, I don't think, because the standing orders for public petitions were grievances that have got allegations. It actually even says grievances with allegations, right? And most of your standard public business acts, which are sponsored by the cabinet and main parties, they're already working on them, and they already give you opportunity to oppose or support those bills through written evidence to the committees that are dealing with them, right? They call for written evidence on those bills, and they're government sponsored, which is what your MP surgery is for partly as well. So I actually think the standing order rules for presentation of public petitions is not actually really meant to be for the ones with other public business as well, although you can petition for those matters, and people did. But if it's a main state-sponsored thing, but the first provision says allegations, so it's got the word allegations in there. So why would it have the word allegations in there if it was the other public business? Because, you don't have allegations to get a bill enacted. So when you call it public petitions, it's actually meant to be like in the Bill of Rights, calling parliaments, to redress all grievances, whether urgent or not, whether related to privilege breaches or not. But the allegations in it are that something has been done wrong. Ironically, public petitions now, the policy is saying that you can't have any wrongdoing accusations. But that's the merit of the provision. That's actually, for public petitions clause, it must contain allegations. But, they've sent all the complaints about government departments to the Ombudsman, Parliamentary Ombudsman. They've got all complaints about MPs to Daniel Greenberg, the Commissioner for Standards. There's hardly anyone doing paper petitions anyway. Now, 50 to 250 a year for the last decade, right? What do they want us to use e-petitions for? They want it to be like policy suggestions for people who aren't hardcore Labour manifesto people with the main government, or someone who's not supporting a private private members club, right? They want it to be kind of like, friendly, they want it to be kind of like simple, very simple, non-threatening, sort of like super straightforward policy recommendations, which falls under amending and strengthening the laws, but they're calling it public petitions. And public petitions is meant to be allegations, and I think separate from other public bills. But you can petition for public bills, and it will fall under there, I think. But it wouldn't fall under allegations, though, would it? Because if it says that if it doesn't fall under that standing order, it can be received, but it's not allegations, then which provision does it fall under? Those provisions need a lot more contemplation, like printing out and putting on the wall and just staring at for weeks on end and just thinking about them until you get all these like enlightening moments coming through, like, eureka moments coming through from putting it all together, like the whole big picture in a historical chronological order, and then you get all these insights happening, like, wow, this Parliamentary Papers Act 1840, but they didn't even have rules for public petitions before then. And they'd only just pretty much got the fees for breach of privilege without it being dealt in the courts, And clearly what is John Tinker talking about? If you get a resolution in the courts, not by the Bar of Parliament, well, surely we get a resolution in the courts by using this. Surely, because, like, why else? What's the point in it? If the main thing that you're doing is printed matter, making printed matter available to the public and employing people to print copies of your petitions, and it's through standing orders of the House, through the standing orders of Parliament, which could be it could be the private business, it could be here preliminary proceedings, right? Standing orders for railways, or it could be public business, like using the Tumultuous Petitioning Act, which we don't have anymore because it's repealed, but it proved that there was a legislated process, and by order of the House of Commons, in 1661, by order of the Speaker, put through, given royal assent, by order that when we are soliciting the signatures to either House of Parliament that it exists, why would we be doing that? To hand them in, right? So the standing orders only kick in really once you've handed them in, and there weren't any till 1842 for grievances until after this. So that all needs to be taken into account.